What are the texts you need to be concerned about when you talk to a claims adjuster? I've been dealing with claims adjusters throughout my entire career. I have a claims adjuster, retired claims adjuster that works for us 2 days a week, been of enormous help. And what I've learned are some things that I need to pass on to you, because nothing that they do is by accident. No call you receive from a claims adjuster, nothing they send to you in the mail. It is there by design, and the design is for them to better understand the case so that they can pay as little as possible in the end of the day to settle someone's claim. That's the entire name of the game. One of the things that I've learned is that it's very common for a claims adjuster to want to put you at ease after a bike crash or after a car crash. They want to put you at ease. They would like to reassure you that they will take care of you. They want you to feel that you can place your trust in them, and that your case will be fairly evaluated and fairly settled by leaving it in their hands. And sometimes they're successful in doing this. I've had some very sophisticated people over the course of my career call me and just basically tell me, I'm going to leave it with the claims adjuster. I trust the person. I think they'll be fair with me. At the end of the day, that type of person will get a settlement. They'll receive a settlement. But the problem is it won't be anywhere near the full value of the case. It just won't. I've learned in my career that if I don't feel in my heart of hearts that I can get my client more money than they would get dealing with the claims adjuster on their own, I will tell you right away that's the case. And then I'll tell you how to do it on your own. But there's some things that you need to be aware of before anyone would ever make a decision to address their case or hold their case on their own and deal with the claims adjuster without the help of a lawyer. I think that, my claims adjuster here, Mark, has told many stories over the years of people he's dealt with. And I think Mark is a fair-minded guy. I mean, he's proved that in his work with me. The problem is when you talk to a claims adjuster from an insurance company, whether it's yours or whether it's the other company, they have one motivation in mind, they have a case, they want to get it off their desk, and they want to get it off their desk at the least possible cost to their company. If they offer you $5, the case is worth $10. It's just the way it works. And the problem with you and I, if you're not in this environment, not working in this arena like I am every day, you have no idea, you have no point of reference, no idea what your case may or may not be worth. It may be worth a lot more than you think it's worth, or it may be worth a lot less than you think it's worth. And the role of your lawyer is to be honest with you and tell you exactly where you are in this process. Hey, Jennifer, thanks for your comments. I know Jennifer's pointing out that there's a lot of people out there, and maybe you're on the line today, that have had an unfortunate experience with a claims adjuster or a situation that kind of left a bad taste in your mouth. You have, let us know. Yeah, Jennifer's again telling me that, she's got a claims background and knows exactly how they're trained behind the scenes to do exactly what I'm talking about right now. Insurance adjusters look at claims differently than I do, than any lawyer does. They are, by nature, they're very suspicious. They don't believe any story. They don't believe any set of facts. They don't believe any injury is as bad or exactly as is being portrayed. They always feel like they're being worked to some extent. So they're always looking at the case through a lens which is totally different than the lens you see as the injured party reaching out to someone at a moment of need, relying on this person to be fair, honest, and open with you and give you the benefit of the doubt. That rarely happens. Can it happen? Sure, it can happen, but it's a rare occurrence in the claims business. Another thing that they do frequently is to try to talk to you about why you shouldn't even get a lawyer. They want you to leave the case with them and not get a lawyer. I've had people come talk to me after they've been involved in even in a serious accident, whether it's a bike crash or a car accident, about how the claims adjuster tried to convince them they don't need to get a lawyer. That's why these companies are trained to intervene right away to try to establish some type of rapport relationship with the claimant, to try to convince them they don't need a lawyer. And what they will tell the person is, by the way, don't hire a lawyer. They're going to take a percentage of your recovery, save that percentage. I'll deal with you directly and you'll come out ahead. There have been many studies. There's a famous one that is floating around, that's been around for a long time, actually promulgated by one of the big auto insurance companies that actually proved internally for them, which later became public, that people who are represented by a lawyer receive multiple times the value of a case compared to the person who tries to handle the case on their own. So the reason they want to convince you not to get a lawyer is because they know at the end of the day, it's going to cost them more money. And the lawyer is going to take the time to build the case to be what it actually should be. I've got a kind of a case in point. We had a case we settled just recently at mediation. Mark and I, my adjuster and I, were talking about it. And, you know, Mark works with hundreds of lawyers across the state and across the country. And he said, Jim, you know, this case in the hands of most lawyers would have settled a long time ago for 10% of the value that you just settled this thing for, because they wouldn't have waited and understood how to work it up, what needed to be done, who the person needed to see, how it needed to be expressed, and how to negotiate and express that to an insurance company and put it in the range where the actual case value was. And that's what, you know, a trained lawyer, it's what we do in our practice, is try to work the case to the point where we're going to receive the maximum value in terms of trying to get the case settled for you. And many times that's multiples of what the insurance company views it at, particularly early on. Sometimes cases need to be worked up properly, and that's one of the values of a lawyer. Another something that they will never tell you is, for instance, if you're on Medicare or health insurance, you're going to get that lien reduced if you're working with a lawyer. Let's say you have a $30,000 Medicare lien that has to be resolved at the end of the case. Number one, without a lawyer, you have no idea how to even do that. And you can get in serious jeopardy with Medicare if that's not handled properly. But if a lawyer is representing you, that's going to be reduced by the percentage of the lawyer's fee. So if the lawyer is charging you a third, your Medicare lien is going to be reduced by roughly a third. If you're handling this on your own, there's going to be no reduction. Okay. And the same thing applies, although there's no structured formula. We're trying to get healthcare liens resolved with health insurance or workman's compensation or the VA. There's a process and a way that a lawyer understands how to do that. So when you factor in, for instance, the amount of money your lawyer saves you on the liens that they get reduced, offset against the fees that they charge, the percentage that you're paying becomes much, much less. And virtually no case we handle doesn't have a significant lien that we work to get significantly reduced to increase the net to our client. So an insurance adjuster would never discuss with you, you know, the back end problems of trying to handle a case on your own and the problems that you can have not understanding how to resolve a lien, what percentage you can expect to get it reduced by, or the complications in your life if you have to deal with it with them. One simple thing would be, you know, when the Medicare, most insurance companies are going to want you to send the check to Medicare. They're going to put Medicare on the check. Can you imagine sending your settlement check off to Medicare and hoping that sometime they send you the proceeds back? We don't do that. We put the check in our trust account. We negotiate with Medicare. And we send them a check directly from our trust account. So it just streamlines the process. So again, this is just a process, a tactic that an insurance adjuster wants to do is to gain your confidence and try to keep you so that you don't want to walk outside and get a lawyer because they know at the end of the day that's going to cost them a lot of money. Let me just look at this note by Jennifer. So Jennifer's pointing out, you know, Jennifer has a claims background, and she was pointing out in her comment, and I appreciate you sending that in, Jennifer. Even the simple fact of calling you and saying, how are you? And engaging you in that simple conversation is all part of a programmed attempt, a device that they use just simply to be nice and appear to be nice and do those things. It's just a process to gain your confidence. So you have to understand that every conversation you have with them, you're being worked to an extent. It's a process. It's designed. It's a plan, and you have to just be careful not to allow it to. It's the easiest thing to do. Just leave it with the insurance company, but at the end of the day, it would be a very, very costly mistake. So another thing that they do right away many times is to send you a signed medical authorization. This would be just a blank medical release form so that they could send that to, they're going to tell you they're going to send it to your medical providers to get the medical records from your injury. But the reality is when you send one of these blank signed medical authorization to an insurance company, your own or the other person's, you've given them a blank carte blanche to your medical history, whether it's related to this or not. Theoretically, every name they can find linking from one record to the next, they'll pour over it. You're referred by a primary care doctor. He's not treating you. They'll get those primary care records. The primary care referred you to an OBGYN. They'll get those records. I mean, it's a chain that they follow. And the problem is you don't know what records they have when you follow their template. So you're not even aware what records they have. And the reason they're trying to build that record history is to understand every argument that anything you have today, you complained of sometime in the past. You saw your OBGYN one day when you were complaining of neck pain and they mentioned it. That becomes a pre-existing condition if you have a neck issue now. So in our practice, we certainly don't hide the ball in terms of what we provide medical doctors, but we always know exactly who they're getting records from, and we have a copy as well. So if we provide a medical authorization, we generally will just get the records and send the records directly to them ourselves. If we provide them a medical authorization, it's to a specific doctor for a specific period of time. It's not just go out and find whatever doctors you want. Your personal medical history that is unrelated to this crash or the injury that you've received is no business of an insurance company, and they have no right to be pouring through your medical history and having that float around wherever they have it float around. And it's just another thing, which is just a trick of the trade and something that you need to avoid. One final thing that I want to talk about today is they will call you, every insurance company, whether it's your own company or the other person's company, will always want to get a recorded statement, okay? They're trained to take recorded statements. And on one hand, you look at it and say, well, I'm just going to tell the truth. What difference does it make? I've seen this bite a client so badly, so many times that it's hard to believe. Many times when you have, even a bike crash, you may have a fractured collarbone that needs surgery, but you may have a hip issue or a knee issue or a concussion the first 24, 48 hours. Get an insurance company calling you right away. They ask for a recorded statement. You talk about the fractured collarbone. You say, well, I hit my head, but I'm not having any symptoms, or I've got a little scrape on my knee, but I don't have any issues with that. And then 2 months from now, you're needing knee surgery, or you've got a concussion issue, but it wasn't mentioned in your recorded statement. Now it appears when it materializes in the medical records a month, 2 months down the line, it appears that it's a new condition, and they're going to argue that it's unrelated to the crash. Why? Because they had an opportunity to talk to you immediately after the crash at a recorded statement, and you played it down, or you didn't think about it, or you didn't mention it to them. So it's an opportunity for them to deal with it now in the picture that it's not related to the injury, but it's perhaps something that happened to you after the fact, what it wasn't told to us at the time, why they changed their story. You can see the way this gets turned and twisted against you. We are selective in giving recorded statements. Many times we won't give a recorded statement, but I will simply call the adjuster and say, I'm not giving you access to my client, but here's exactly what happened, and these are exactly their injuries. In certain situations, if I am convinced it's going to help us, we'll give a recorded statement. Sometimes if it's your own insurance company, you may have a responsibility under the terms of your own policy to give a statement, and you need to understand that. but those are relatively few and far between in the big scheme of things. Most of the time, we're dealing with this on the other driver's insurance company trying to get information from you right out of the chute. So those are some of the most common things that I think clients deal with right away after a bike crash or car injury. I want you to avoid them. I want you to understand the process. I want you to do those things that are best for you. I always tell clients, listen, you have a life to live and you have an injury. Your injury is part of that process. You're going to make decisions that are best for your life, but the injury claim is an important part of that as well. And let's make decisions that, while in helping your life, are going to help your claim. And that's the role that we play as a lawyer in trying to help you through this process. I've got a free report I want to give to you. Be aware of the tactics used by claims adjusters. And we talk about these very things I've talked about today and several others. I think you find this helpful. Just go to the bit.ly link that Katie's going to put on there, the bit.ly tactics to watch for. I want to thank you for listening to us today. I'm Jim Dodson, the Florida Bike Guy. You know, friends don't let friends call a 1-800-mystery lawyer after a bike crash or after a car injury. We appreciate your referrals. All your referrals will be handled by me and by my team. And I look forward to hearing from you if I can help you. I'll see you next time.